Good morning, Miss Vespa. Welcome back. Oh, is Miss Vespa frozen? Good morning, Miss Vespa. Can you hear me?
I do notice that she's on mute.
Mr. Weeb, how are we doing on the roll call? Oh, it'll be, I mean, there won't be, it probably similar to yesterday. A lot of the, obviously the panel experts that may not be on, but.
Yeah, we're around 30 participants, and I think yesterday was around 40, so a little bit less.
Sorry, Mr. Chair, I don't know if you spoke to me, but I had my speaker turned off, so.
I've done that a few mornings. Yeah, I was just welcoming you this morning. Nice to have you back. Good morning.
Thank you.
Just let me know when you want me to take that screen share down.
Yeah, maybe about 1 minute. I'm just having a look at the names here, just see if I can recognize if there's anybody missing. Okay, I think you can take the screen down now, Mr. Weep. Thank you. Well, good morning, everyone. Welcome day 11. I think it's day 11, the final day of the hearing, and for Alberta Transportation's reply argument. Before we start, though, I would ask if there's any preliminary matters anyone has to deal with this morning. And hearing none. And I'll just maybe quickly check. Mr. Secord, are you online?
I am online, yes, sir.
Okay. And Ms. Loudon? Or Mr. Ray?
Yes, sir. It's Mr. Ray. We are here this morning.
Okay. And it looks, so I think it's checking. Everybody's got, the names are up for all the main parties. So Mr. Krulak, Mr. Fitch, Mr. Barbero. I'm not sure if it's a tag team approach this morning or not, but whoever's leading off, the floor is yours. Please proceed.
Thank you, Mr. Chairman. It's Ron Krulak, and I'll lead off with some brief comments with respect to the submissions made by the Stoney Nakoda Nations, and then my friend Mr. Fitch will speak to the comments that were provided by the SCLG. I think our comments will be relatively brief, Mr. Chairman. So they're in respect to the final argument, which was marked as Exhibit 413 yesterday. And I guess as a general statement, similar to as made in our reply submissions, we obviously have some fundamental disagreements with the characterization of some of the facts and the law as tendered by the Stoney Nakoda Nations in their final argument. I'll just refer to several specific references and noting in the initial paragraph, as we commented on in our reply document, which is Exhibit 325, in paragraph 223, the Stoney Nakoda Nations make reference to their ongoing claim for Aboriginal title and rights in the Court of Queen's Bench. And as we have previously mentioned to the board, we would respectfully suggest that this process decline comment on matters that are before the courts involved in that litigation. In paragraph 12, the Stoney Nakoda Nations submit that in the conclusion of their paragraph, over the last 2 weeks, the board has heard evidence of Alberta's haphazard consultation process with the Stoney Nakoda amid the limitations created by COVID-19 on Stoney Nakoda communities. Mr. Chairman, obviously we have to take exception to that characterization that in fact, what the board did here in the last 2 weeks through the references to the record of consultation was what we would characterize as a complete and fulsome effort at consultation. And I would indicate that that went on for a number of years, some 5 years prior to even the commencement of the COVID-19 situation, which has impacted the Stoney Nakoda Nations. So we obviously have made references to the degree of consultation and the quality of it, and continue to be of a view that it was reasonable, and for the board's purposes, we would submit that it was adequate. In paragraph 14, the Stoney Nakoda Nations of their arguments say that consultation with Indigenous groups generally is not consultation with the Stoney Nakoda. Negotiations and agreements with Tsuut'ina and other distant First Nations bear no relevance to the rights of the Stoney Nakoda. For Alberta to imply that consultation with unrelated Indigenous groups constitutes consultation with the Stoney Nakoda is extremely disrespectful. Mr. Chairman, Alberta Transportation agrees that consultation with other Indigenous groups is not consultation with the Stoney Nakoda. And in fact, despite my searches through our documents and submissions and checking with our consultation personnel, we cannot find any reference to that argument being advanced by Alberta Transportation. So again, it's clearly our position that we agree that that would not be a fair way to interpret consultation, but that is not anything that Alberta Transportation has advocated. The Stoney Nakoda Nation's argument makes reference in their paragraph 17 and 1820 with respect to their assertion of Aboriginal and treaty rights, and I think those have already been responded to adequately in the reply, Alberta Transportation's reply document, Exhibit 325, and I can refer to paragraphs 226 and 227. Similarly, I just want to briefly comment that the characterization of the duty to consult and the explanation of it provided by the Stoney Nakoda in their paragraph 15 of their argument would not meet what Alberta would describe as a fulsome discussion of the duty to consult. We provided references in our paragraph 246 of our reply, which is Exhibit 325, which footnotes the Government of Alberta's consultation policy. And for board counsel, I simply refer also to a leading case, which is Ben and Moulton Contracting Ltd, and Ben is BEHN, and Moulton Contracting Ltd, a 2013 Supreme Court of Canada decision. And those reports at page 26, paragraph 27, 29. I want to briefly also comment on a reference which is referred to in paragraph 18 of the Stoney Nakoda's argument, and that is referring to Elder John Snow Jr. spoke of the trauma he still feels as a result of the flooding and desecration of Stoney Nakoda grave sites resulting from the Bighorn Dam. And such a situation is intolerable and must not be permitted to happen again. It's Alberta Transportation's information that's been provided in the record that no grave sites have been located to date in the SR1 PDA. And in fact, the map tendered by the Stoney Nakoda Nations in their evidence in Exhibit 288 essentially showed that there is no anticipated burials within the PDA based on the depiction they included within that map. I thought it may be helpful, Mr. Chairman, just to provide the board with some comments on the conditions that the Stoney Nakoda Nations advanced. So you have Alberta Transportation's response to those proposals as for the board's consideration. And the first set of proposed conditions was at paragraph 22, which were under the preamble. In the event the board approves the project, the Stoney Nakoda submit that the construction of SR1 not be permitted to commence until and only if. And then the first item deals with seeking to be made a party to the TransAlta and Province of Alberta water agreement. And the second item deals with a full assessment of all proposed flood and water control structures on the Bow River upstream of Calgary. Mr. Chairman, we submit that those issues involving TransAlta and the province, or the Bow River and potential future upstream control structures, were canvassed through this hearing, and I thought had been concluded that they are not relevant to the issues before this board in reviewing the SR1 project. Further, there's a reference to the indication that Alberta must obtain the full and free and informed consent of each of the Stoney Nakoda Nations. And there's also reference in the following paragraph 23 to UNDRIP and Alberta's commitment to it. And I would just simply refer the board back again to Alberta Transportation's response to UNDRIP, which was in undertaking number 5. There is also a lengthy set of conditions requested under paragraph 24. The list includes some 16 conditions, which I'll just briefly speak to. Condition 1, completion of Stoney Nakoda traditional land use assessment. Alberta Transportation is in agreement with that, and as it's tendered in its opening statement and through the course of further submissions in our argument, it is looking forward to receiving the final traditional land use assessment from the Stoney Nakoda Nations. Condition 2, cultural awareness training, which Alberta Transportation submits that this has already been proposed in the Indigenous Participation Plan. I think I can refer to the board to Exhibit 216, PDF 13, which is a commitment to all First Nations, to which we'd welcome the Stoney Nakoda Nations being involved with. Condition number 3, information sharing agreement. Alberta Transportation would be agreeable to developing that agreement between itself and the Stoney Nakoda Nations. It can't seek to compel Alberta culture, multiculturalism, and status of women to such an agreement through the course of this arrangement. Condition number 4 is in reference to an independent Indigenous monitor. And based on the description of that condition, Alberta Transportation finds it unclear and would welcome further discussion with the Stoney Nakoda Nations with respect to that issue. Condition number 5, Stoney Nakoda Traditional Knowledge Monitoring Committee. Mr. Chairman, we'd submit that Alberta Transportation has already advanced extensive commitments to undertake a variety of forms of monitoring with respect to the project. And we would suggest that this also be an item deferred to further construction after the Stoney Nakoda Nations submit their final traditional land use assessment. Condition number 6, Stoney Nakoda Archaeological and Heritage Management Plan. We can advise that Alberta Transportation has already made a proposal, which is made reference in its opening statement and further documents with respect to providing Stoney Nakoda participation in the further archaeological work which is planned to take place at the PDA. Condition number 7, previously recorded archaeological and historic sites. We can advise that that has already been provided to the extent it's been possible under the restrictions that Alberta Transportation finds itself under with respect to the provisions of the Historical Resources Act. Condition number 8 is the Stoney Nakoda Nation Sacred Ceremonial Objects Repatriation Regulation. This condition appears to be a request to fund what is essentially a law reform initiative on behalf of the Stoney Nakoda Nations, and Alberta Transportation would not be in a position to undertake that funding. Condition number 9 is again made a reference to the wildlife overpass, and Alberta Transportation has provided its position on that earlier, and that is not changed, that it is not, based on the evidence that has been reviewed and presented to this board, finds that that structure is necessary. Condition number 10, Crown Land Offsets Measures Plan. Again, Mr. Chairman, this request appears to be more suitable to what might be a more typical project involving Crown land, and would not be viewed to be necessary in the circumstances of this project and the nature of it being on largely private land. Condition number 11, water monitoring for Wasta Ignaknabi LTD lands. It's my understanding that that site is currently outside of the planned monitoring area, having regard to its distance from the project development area. Condition number 12, seeking to be chair of the Indigenous Advisory Committee. Mr. Chairman, I think Alberta Transportation believes that that would be a matter that's best suited for discussion among all the interested First Nations when that committee is initially structured and set into operations. Condition 13, Stoney Nakoda Communications Plan. Mr. Chairman, Alberta Transportation's already committed to developing a communications plan that will be in place prior to construction, and encourages the Stoney Nakoda Nations and other Indigenous groups to be participating in that plan. That plan was presented in Exhibit 216, PDF 10 of 24. Condition 14, funding for participation in conditions or programs. And my response will also deal with the next condition, funding for consultation on conditions. I think you've heard, Mr. Chairman, that Alberta Transportation has invited the Stoney Nakoda Nations where they see that they need assistance to review aspects of this project or to be involved. The practice has been to make a request and provide a budget for the expected resources required, and Alberta Transportation would be pleased to consider that and get back to them, as they have done in the past and as they have provided funding in the past. Condition 16, Mr. Chairman, our review of that condition appears to be that it's more directed to the NRCB than Alberta Transportation, so we would defer comment on that. Mr. Chairman, I just have some final comments with respect to these type of requests, and that is, if the board was to approve this project and is contemplating crafting conditions, we would encourage the board to consider that Alberta Environment have the ability to actually be the party to fulfill those conditions, as it reminded me of perhaps some of the challenges that might be raised where conditions are fulfillment might be left to a third party, which would make it perhaps difficult to ensure the condition could be achieved to maintain schedules which the project would be hoping to achieve. Secondly, Mr. Chairman, the board finds itself in a situation with a federal review being undertaken, and that review process also generating conditions. And we trust that the board might consider that conditions may require some coordination between the respective agencies. So with that, Mr. Chairman, as I'll be passing the mic over to my friend, Mr. Fitch, I echo his comments of thanks yesterday, and I wish the board well in its deliberations.
Thank you, Mr. Krulak. Mr. Fitch.
Yes. Good morning. No, I don't seem to be. Can you hear me, Mr. Chairman?
Yes, loud and clear. Perfect.
Oh, okay, good. So I will be providing reply argument on behalf of Alberta Transportation, primarily with respect to the argument of the SCLG. I may have one or so comments in relation to Cal Alta and Mr. Wagner. So, Mr. Chair, to begin, there was a bit of debate yesterday about the SCLG the written version of their submissions, and the fact that, let's be honest, they contain a lot of material that Mr. Secord was not able to orally deliver within the allotted 2.5 hours. I think our final position, having thought about it a bit more, is that we do think it pushed the boundary a little bit, but we're not going to object. It's been marked as an exhibit, and that's fine. The bigger issue, though, as we thought about it last night, is one reason that the argument was frankly too long for the written version of the argument was too long for Mr. Secord to deliver orally, is that it seems quite clear that many paragraphs were added literally in real time yesterday morning, responding to Alberta Transportation's argument. So, for example, you could look at paragraphs 346 to 360 of SCLG's written argument. These, it seems quite apparent, were written by Dr. Zelt, responding to Alberta Transportation's final argument. And you may recall Mr. Secord dealt with some of them where he literally said, in paragraph X, Alberta Transportation said this, and in response, here's my position. And I think it's fair to say, I think there were also paragraphs like that added by Dr. Fennell and potentially others. The point of all this, Mr. Chair, is that the applicant always gets the right of reply. And as we lawyers know, the reason is that this, at the end of the day, is our application. Therefore, we have the ultimate onus to persuade this board that approval of the project is in the public interest. Interveners don't have the right of reply in argument. And what's happened here is that by virtue of the fact that this is a virtual hearing, the SCLG essentially has provided reply argument in addition to their written argument. And, we all know that the procedural rules are quite flexible in administrative hearings like this, but there have to be some rules. And I'm just going to finish on this by saying that we think that this was something new. I've certainly never seen it, where an intervener provides extensive reply argument in their argument. And we just ask the board to keep in mind whether or not that really is something that's appropriate. So the next thing I'm going to do, Mr. Chair, is just offer a few really, I guess, high-level comments with respect to SCLG's written argument, oral argument and written argument. And those comments are as follows. Alberta Transportation understands that members of the SCLG are opposed to this project. And we accept that, like happens with many, if not most, resource projects, the impacts of the project are borne to a greater extent by the people that live closest to it. So in this case, that would include members of the SCLG. So we do understand all that. It's not like we're deaf to all of this. We do understand it. But in our view, what we've seen here is this opposition to the project that sort of manifested itself through the SCLG has led to an intervention that essentially saw the SCLG trying to find something, anything that they could latch on to try to stop this project. And what that resulted in is an intervention that whose hallmark in my submission was advocacy and argument right from the very beginning. And again, we get it. We know that the SCLG doesn't want this project to proceed, but we question, Alberta Transportation questions, and we ask the board to ask itself what was the utility at the end of the day in such an approach, in assisting this board in carrying out its task of determining whether the project is in the public interest. Because it really all kind of comes down to this almost existential question of should it have been MC1 or some other project versus SR1. But the reality is, Mr. Chairman, that horse left the barn a long time ago. And the real issue is whether approval of this project is in the public interest, having regard to its social, environmental, and economic effects. And it's unfortunate, I think, that so much time and effort was focused in on this other issue, which frankly just isn't part of the board's review. So those are just sort of our general high-level comments. I'm now going to address some specific submissions that appear in the written version of the argument of the SCLG, beginning with their submissions on the public interest test. Paragraph 3, the rhetorical question is asked, is this just simply better than nothing? Is that the public interest test? And Mr. Chair, Alberta Transportation rejects that characterization. The public interest benefits of SR1 have been fully canvassed, we submit in the evidence. But to be clear, in our view, nothing is not acceptable. And you heard, for example, from CRCAG about that. The status quo, no flood mitigation on the Obo River, is not acceptable. And further on in the submissions, my friend alluded to the evidence of, I think it was Marshall Coppathorne, to the effect that it's never too late to reverse course. We disagree. We think it is too late, and we caution the board about going down that road, because no one can say with any certainty how long it would take, if this project were not approved, how long it would take for some other project to be fully developed, applied for, and approved. But I think we can all agree it would be years, and likely many years. And in our submission, that's simply not acceptable given the urgency of this project. Next, Mr. Secord referred in his argument to the Cougar Creek decision, and one of the reasons he referred to it is a passage in there that the board has said that one of the factors it looks at when considering public interest is does the project have the support of the community? And Mr. Secord's argument was no, it does not. And we submit actually there is a lot of support for this project. Yes, again, we understand that members of the SCLG and the most local of the communities are not all in favor, and many are strongly opposed. But in terms of the community, given the purpose of this project, which is to protect downstream communities, including the city of Calgary, in our submission, there actually is significant support from this project, from the city itself, from CRCAG, from Flood Free Calgary, from the Earlton Community Association, and others. So actually, Mr. Chair, we say there is a lot of support for this project. Next, my friend Mr. Secord refers actually at some length in his argument to the board's decision NR 2008-01, which is the revised Highwood diversion plan. And a number of submissions are made about what the board said in that decision about the considerations that apply when a water management project is before the board for consideration. And in response, Alberta Transportation says the following. I mean, we don't need to tell this board what it decided in one of its own previous decisions. But what we will simply point out for the record, and again, which I'm sure you know, Mr. Chair, is that the Highwood diversion project was not a flood control project. It was a water management project. That's why there are all those passages in that decision to what the board should consider when it is assessing a water management project. But again, this is a flood control project. And again, we understand from the submissions of the SCLG that they actually wish this was not just a flood control project, but rather also a water management project. But again, that goes to, we have to deal with the project that's before us, and that's a flood control project. So at the end of the day, we submit that our friends' references to the NRCB's 2008 decision and the Highwood diversion are not of assistance in this case. There's also a reference made to the original Highwood Little Bow decision from 1998, and that was in the portion of my friend's argument relating to alternatives. And you might recall that there's a passage highlighted that suggests that 12 different alternatives were assessed in that case. But I'm sure you noticed, Mr. Chair, that if you actually kept reading the sentence that was highlighted, in fact, what it says is that there were 12 projects that had been reviewed by the Prairie Farm Rehabilitation Administration in 1965, and that these 12 projects were reduced to 8 and then ultimately to 4 for consideration for further review. And in our submission, that's actually not much different from what's happened in this case, because before the ultimate decision to select SR1 was made, there were 3 different projects that had been advanced for some level of review, namely MC1, Calgary Tunnel, and SR1. Just one comment about a passage in paragraph 13 of the written version of the argument. SCLG states that Alberta Transportation, quote, explicitly, end quote, refuses to disclose material costs. Not sure what was meant by the word explicitly, but if the implication is that Alberta Transportation is intentionally refusing to disclose material costs, we reject that assertion, Mr. Chairman. There are several places in the argument of the SCLG where they either explicitly or implicitly argue that MC1 is superior because it could handle larger floods, 1 in 500, 1 in 1,000, 1 in 2,000, or the probable maximum flood. And to be clear, Mr. Chair, that is simply not correct. And I would refer the board, when it is considering this issue, to Exhibit 101, which is the Opus design report for MC1. And if you have a look at it, you will see that Table 6-1 on PDF page 46 shows the discharges from MC1 in the various flood scenarios. And basically what it shows is that once MC1 gets to its design flood, it will continue. Water will now pass just as it will at SR1, and indeed just as it does at any dam. And in fact, what that table shows is that for probable maximum flood, or PMF, the peak outlet discharge rate would be 1,000 cubic meters per second, not the 212 that my friends keep referring to. And, you know, on this issue, while MC1, because it's an in-stream dam, we do know, the evidence was clear that it can continue to discharge at a constant rate of 212 meters cubed per second up to the design flood. And of course, SCLG says that makes it superior to SR1, but we remind the board that this same characteristic increases risk. It increases risk in construction and in operation and in debris management and in the event of emergencies. So the benefit associated with a constant discharge up to the design has to be weighed against that increased risk. So it's not nearly as simple as the SCLG would have you think. Next, we were all struck in this room by the analogy our friend Mr. Secord drew to vaccines, which was pursued in a number of places in their argument. And let me suggest a different way of looking at that analogy. Currently in Canada, to deal with the COVID-19 pandemic, there are 4 vaccines approved for use. I think we can all agree. And a lot of, there's been a lot of speculation, or it's been reported in the media that some people have been wondering, which one should I take? Is one better than another? And I think we can agree, Mr. Chair, that the answer that the public health experts have given is, take the first one that you can get. They're all effective. Take the first one that you can get. So if we apply that to this case, the first project that you can get to effectively deal with flood mitigation on the Obo River is the one that's before us. And again, if we don't take this one, we're looking at the passage of many years before we're going to get another. Alberta Transportation also feels compelled to observe that we saw in the argument of the SCLG, as indeed we saw throughout the hearing, frequent and I would say casual use of certain catchphrases like contaminated water or mud pit. And, you know, we didn't, during our friend's cross-examination, really object to all of these characterizations. But I think Alberta Transportation does want to say, for the record, that this idea of the water being contaminated has no foundation in the evidence, none. The water that enters the reservoir is the same water that's in the river. And then it's going to get released and go back into the river. So this is just not correct, and it's a completely unfair characterization. At paragraph 89 of the written version of SCLG's argument, there's what I would characterize as a reply to our position on the Rocky View County Land Use Bylaw. And Mr. Secord said there's no evidence in the record about the bylaw. And in response, I say it doesn't matter because it's a law. It's not evidence, it's a law, it's a legal authority. So it doesn't have to be in evidence. And Mr. Secord also suggested that the fact that it's a 2020 bylaw that just came into effect in, I think, January of 2021 is relevant and that it doesn't retroactively apply. And in our submission, that entirely misses the point, which is that in Rocky View County, as indeed elsewhere throughout Alberta, municipal districts either discourage or outright prohibit development within the 1 to 100 year flood hazard zone. And the relevance of this, as we've already said, is that by reducing flows from a design flood to the equivalent of a 1 in 50 year flood, SR1 will protect the vast majority of properties, not just downstream of the reservoir, but also upstream of Glenmore Reservoir. With respect to costs, Mr. Chairman, the SCLG argument dwelt at considerable length, I would submit, on costs, and I think, you know, our position on costs, I think, is pretty clear. But what I want to say, just by way of, I guess, the final point we'd like to make is that it's quite clear what's going on here, which is all these questions about, well, what's the cost of this and what's the cost of that? There's all these unknown costs, these hidden costs, and all the other costs that we know about have increased. It's all ultimately in aid of the MC1 is better than SR1 argument, right? It's all about saying that one reason SR1 was chosen was because it had a higher benefit cost ratio than SR1. And now look at all these costs. Now it's different, and MC1 is better. And at one point, my friend referred to, I think it was in paragraph 127 of the written argument, that, quote, MC1 is the project with the better economics at this point. Well, just think about that statement, Mr. Chair. MC1 is frozen in time. It was never more than a conceptual project, and it's basically frozen in time as of 2017. And to say, and to embark on an exercise where you're looking at how the costs of SR1 progress every month, year, whatever, and then compare it to MC1 and say, aha, MC1 is now better, that's just not valid. Finally, just one comment on the section of SCLG's argument on consultation. There's a suggestion that Alberta Transportation pitted neighbor against neighbor, and that there was never any attempt made to find a win-win solution. And Mr. Chair, again, I don't think Ms. Hunter or anyone else at the SCLG would deny that the win for them is that SR1 doesn't proceed, and that something else go ahead. And viewed in that context, I ask, you know, how do you arrive at a win-win solution when one party just says, this is the only win for us? So consultation is always difficult in terms of satisfying everyone that you carried out proper consultation, but it is always the case, I would submit, Mr. Chair, that there are some people that are not going to ultimately be happy and who are going to consider that they weren't properly consulted. But again, if it's hard to consult when someone's position is so fixed and inflexible. With regard to design, safety, and risk, just a few comments. We noted that our friends asked that recommendations 1, 2, 15, and 17 from the Austin report be imposed as conditions. And Mr. Chair, we've already dealt in our argument with our position on all of the Austin recommendations. I just simply reiterate here that it is for the Director of Dam Safety to review and decide whether those recommendations should be implemented or not. And so we don't think, therefore, it would be appropriate for the board to impose any conditions related to the recommendations of Austin Engineering. My friend briefly referred to, in paragraph 263, to the fact that there was an error made by Mr. Wood in that snowpack data, you may recall, from the Elbow, I think it was the Elbow Summit station. And I just simply say that while Mr. Wood acknowledged that he had made an error, he also went on to say that it didn't change anything. It did not affect the analysis that had been carried out. It was something that actually arose at the hearing, and it does not change Alberta Transportation's climate change assessment results that used IDF data and hydrological modeling for climate change impacts. So in our view, Mr. Chair, it's a non-issue. Just turning to water, I noticed Mr. Secord mentioned that his client, Mary Robinson, is concerned about the head pond backing up onto her property. And in reply, Mr. Chair, this was addressed directly during my redirect of the topic 3 witness panel. And you recall there was a map that we were all looking at, Exhibit 131, PDF page 565. And what that map shows, Mr. Chair, is that the head pond does not get particularly close to Ms. Robinson's property. And by that I mean her what I would call her home quarter, the southwest of 3. The head pond doesn't even impinge at all on that property. In paragraph 287, there is what I would characterize as a bit of a throwaway comment about the absurdity, that was the word that was used, of Alberta Transportation's fish rescue plan. And I would just simply say in reply that that assertion is contrary to the evidence of the SCLG's own expert, Mr. Locke, who clearly doesn't think it's absurd, but rather explicitly said it was reasonable. There was quite a bit of argument from SCLG with respect to hydrogeology, just as there had been a lot of cross-examination on the issue. And Alberta Transportation does want to make a specific reply to paragraph 290, that's 290, of the written version of SCLG's argument, because that's where they characterize Mr. Yoshisaka as having been evasive, and Mr. Secord referred to the fact that sometimes he had to ask questions 3 different times. Mr. Chair, Alberta Transportation submits that's a completely unfair characterization. Mr. Yoshisaka was not evasive in our submission. Rather, the reason Mr. Secord had to ask questions several times was because he just wasn't getting the answers that he was hoping he would get. And that happens all the time in cross-examination, as I'm sure you know. In our submission, Mr. Yoshisaka was entirely credible. It was a long, tough cross-examination. He was quiet, calm, patient, thoughtful, and we are very comfortable leaving it to the board to determine which expert on hydrogeology the board thinks is more credible. In our submission, there's no doubt that Mr. Yoshisaka was an entirely credible witness. Still on hydrogeology, Mr. Chair, again, I think there were a number of paragraphs in the written version of the argument that were written in response to what Alberta Transportation said in its argument. But I don't want to get into the details of which layer is above which layer and what the conductivity of the water is, etc. But I do want to just, as an example, I guess, draw to the board's attention paragraph 295 of the SCLG's argument, where a very basic assertion is made. The K value for the top 3 layers is indicated as being 7.2 times 10 to the minus 8 meters per second. Well, that's just not correct, Mr. Chair. The K value, in fact, is 5.10 times 10 to the minus 6. This was one of these points where Dr. Fennell had advanced his position, and it was actually shown on cross-examination to be not correct. And yet here we see it again showing up in final argument. So it doesn't matter, whether Dr. Fennell was right or wrong, it's his position. And so the submission I guess I want to make about the portion of the SCLG's argument on hydrogeology is that it's obviously based on the evidence of Dr. Fennell, and frankly, in our submission, Dr. Fennell was more an advocate than an independent expert, and you can see that because in these paragraphs of the SCLG's argument, he continues to argue points that were demonstrated on cross-examination not to be correct, and yet it doesn't seem to have made any difference whatsoever. And I'm just going to leave it at that. So turning then to topic session 5, the suggestion was made beginning at paragraph 325 of the SCLG argument that there will be unsafe PM 2.5 levels at area schools. And in fact, Mr. Chair, Alberta Transportation's air modeling does not show any exceedance of PM 2.5 at any of these schools. And this can be clearly seen at slides 13 or 14 of the PowerPoint presentation of Mr. Person, which was part of the opening statement of Alberta Transportation in topic session 5. But to be clear, you know, this suggestion that the children at these schools are going to be exposed to unsafe, unacceptable levels of fugitive dust emissions, that's not at all, Mr. Chairman, what the evidence shows. I think the only other thing I want to say on air is I've already drawn to your attention, Mr. Chair, that beginning at paragraph 346 of the written version of SCLG's argument, there's about 15 paragraphs where Dr. Zelt, I think it's quite clear, responded to our argument. And in those 15 paragraphs, Dr. Zelt uses the word bias 7 times. And Mr. Chair, Alberta Transportation understands that, you know, in a contested hearing, emotions can run high. Usually, though, that's something that happens with, you know, the interveners themselves. They're emotional because it affects them personally. It seems to us fundamentally different when you're talking about experts. Experts are supposed to be independent and objective. And of course, experts disagree. That we wouldn't have hearings if experts didn't disagree. If they all agreed, there would be no hearings. But just because someone holds a different view, some qualified expert holds a different view from you, that does not make that person biased. Bias, Mr. Chair, in our view, is a serious allegation. And with all due respect to Dr. Zelt, I think this fairly indiscriminate use of the word bias discredits him. And so that's all I'm going to say on that. So you'll be very happy to hear, Mr. Chair, basically at the end of our reply submissions. I just want to conclude by picking up on a few things my friend Mr. Krulak said, and that just relates to conditions. Generally speaking, I guess I would say both the Stoney Nakoda Nations and the SCLG, and also Mr. Williams for Cal Alta and Mr. Wagner have urged upon the board that you impose a fairly lengthy set of conditions on an approval, if granted, for this project. And Alberta Transportation just asks the board to be cautious in assessing these requests for conditions. And in our view, assessing the appropriateness of any given condition, the board should be asking itself the same question really as it asks itself with respect to the project generally. And that is this condition really required to make approval of the project in the public interest? In other words, conditions should not be imposed unless they contribute to making a project in the public interest. So, for example, and this I think will be my only reference to Cal Alta, one of their suggested conditions is we are asking Alberta Transportation to recognize and compensate for the lands that are sterilized for the life of this agreement. That's the franchise agreement. And our beneficial right, that's again under the franchise agreement. And then we are requesting the board to make this objection a condition of approval. Well, with respect, Mr. Chair, a condition that a proponent compensate another party for alleged sterilization of rights under an agreement, it's just simply not an appropriate use of the condition power. So I use that just as an example. I think there are others, but again, we just simply say to the board, look, we do understand there will be conditions. In the event the project is approved, we understand and accept that there will be conditions attached to any approval. But we don't want to see conditions that don't actually contribute to the public interest. That's, I guess, the point I'd like to finish with. So, Mr. Chair, I'm just going to ask if I may quickly consult with Mr. Hebert, but I think Alberta Transportation is done, but I just would like to check if that's all right with you, sir.
Absolutely.
Thank you.
Thank you.
Mr. Chairman, board members, that is indeed the end of the reply submissions of Alberta Transportation. Like my learned friend, Mr. Krulak, I want to reiterate the thanks of Alberta Transportation for the board's patience through these last 11 days. And we know the job you now have is challenging, and we're happy to leave it in your capable hands, and we look forward to receiving a decision in due course.
Thank you, Mr. Fitch, and thank you, Mr. Krulak. I do have some closing remarks on behalf of the panel. And really, a lot of it are notes of appreciation, and I think they're warranted. I'll only be about 5-6 minutes, but I think they're warranted given the length of time and commitment that all of the participants have shown through the last essentially 2 weeks of hearing. And I think Mr. Wiebe is going to throw up the panel members in these different speaker views and gallery views. I think we've been somewhat recognizable because of our backgrounds, but sometimes maybe hard to find us, including our legal counsel, Ms. Vance and Mr. Kennedy. So, and I'm also appreciative of the fact that we were able to have a YouTube feed for the public, and I certainly hope that that worked out well for those that, of course, weren't able to join within the sort of the virtual hearing room that we had. I know that their views in terms of the virtual view that YouTube can provide is a little bit different, so it may have been a bit more awkward for some of the YouTube viewers to sort of kind of figure out the parties as we were switching back and forth. But hopefully, after at least some time, they got somewhat familiar with the names and some of the faces, and were able to piece that together virtually. And perhaps there's some, perhaps many folks that were able to participate via YouTube that may not have been able to participate at all if we were in our old school in-person hearing. So, and thanks for the technology and MNP for having that or allowing that to happen. So we took a different approach for this hearing, a new approach for the NRCB, and we instituted time limits, as you know, for all participants. We asked each of you how much time you required for direct evidence, cross-examination, and final argument, and the board approved those requests. And it would only work if you folks made it work. You needed to be organized and have some buy-in by the applicant, Alberta Transportation, but also interveners. And we did get that buy-in. And with only a few minor exceptions, those time allotments were honored. All of you showed, in our view, tremendous respect for the process, and we really do appreciate that. I would like to once again thank NRCB staff who stepped up to manage documents online. I had the document managers up on screen last week to thank them, but did want to once again acknowledge their hard work over the course of the 2-week hearing. And a big thank you to Mr. Justin Wiebe with MNP, who Zoom hosted the entire hearing. Mr. Wiebe, you flew solo the entire hearing and did so remarkably well. You had participants up almost instantaneously into speaker views. You rearranged the speaker views in order to make sense for those viewing. And every day you started admitting participants pretty early in the morning, and we concluded fairly late in the day, and you did that all on your own, and we really do appreciate it. So on behalf of the NRCB and all the hearing participants, I'd like to give you a big thank you. As many of you have mentioned in your closing remarks, Ms. Friend has been an incredible resource and help to you. On top of the work that she's done with all of you, she also supports the board and board staff. Ms. Friend and Mr. Wiebe, you could perhaps bring Ms. Friend up on the screen as well. Ms. Friend, if you could have your video on. You've been amazing support to the entire hearing process, and on behalf of the panel and again all the participants, a big thank you. And of course, for the board, we have Ms. Vance and Mr. Kennedy, our legal counsel. This is Ms. Vance's first hearing with the NRCB, and she flattened a pretty steep learning curve because of her, with her sharp intellect and plain old hard work. Ms. Vance is an extremely capable legal counsel and an extremely hard worker. Mr. Kennedy, you have been and continue to be a huge asset to the board and our stakeholders. For those of you that don't know, Mr. Kennedy joined the NRCB way back, and sorry, Mr. Kennedy, this will perhaps age you a little bit, but he joined the board upon its inception in 1991, some 30 years ago. Many of you have come across Mr. Kennedy in past hearings with the NRCB perhaps, or in some of Mr. Kennedy's work with the ERCB or the AUC. And you know him to be calm under fire, well-reasoned, and an even-handed approach to his counsel. So Mr. Kennedy, I would like to thank you for your guidance and assistance that you provided this panel and to me personally as chair. I know all of you have thanked court reporters, and what an incredibly difficult job they have. We all rely upon those transcripts heavily, both by the participants, the parties through the hearing process as you prepare for each day, but also, of course, for the panel in our deliberations. We rely heavily on those transcripts. Big thanks to Ms. DePaulo, Ms. Gabrant, and Ms. Vespa, who's with us again today. And I think you, Ms. Vespa, have spent the most time during this hearing process, and it's been delightful working with you. Thank you very much. And the panel has benefited. You don't see these folks, so you might see their names on the hearing panels, but our environmental technical experts with the NRCB have been a huge help to the board in terms of reviewing the EIA and assisting us with technical questions and matters that we have. Mr. Mike Emonishin, Ms. Stephanie Fleck, Mr. Scott Cunningham, and Ms. Karina Weisbach have attended the entirety of the hearing, and they all bring their unique expertise to assist the panel in the review of the EIA and also the evidentiary portions that we received throughout the hearing. So a big thanks to our technical staff. And of course, the panel would like to thank all of you, all of the parties, for your participation in this review process, including all of the legal counsels who have been excellent. We would like to thank all the parties for the enormous amount of work that you put into preparing for the hearing, and indeed the amount of energy many of you have put into advocating your positions on the project since 2014. You did so professionally, constructively, and respectfully, and we appreciate that. And I would like to thank, on behalf of all of us, and send our appreciation to the Stony Nakota elders that participated and shared their views in the hearing, but also for their prayers. So thank you, Elders Jackson Wesley, Elder Henry Holloway, and Elder John Snow. And given that this is the last day of the hearing, and with only Alberta Transportation's reply on the agenda, it's clearly a short day. And I expect that there may be applicant and intervener experts and impacted landowners that may or may not have been able to join via YouTube today. So I would ask that the respective councils pass along the panel's sincere gratitude for all the work they have done for this process and the commitment to their cause over the years. The panel is keenly aware that this decision weighs heavily on landowners. Should the project be approved, there's direct impacts to those landowners who must give up land, and in some cases, heritage ranches. If the project were to be denied, the further delay in flood mitigation would clearly weigh heavily on the many landowners and businesses impacted by the 2013 flood. The entire panel have all the parties have our heartfelt appreciation for the time, effort, and emotional investment that all landowners have put into this process. So the panel takes our responsibility seriously. We understand that our decision to determine whether this project is in the public interest will impact many people for years to come. The entirety of the record, including transcripts and submissions to this hearing, will be considered in reaching our decision. And our long-standing performance target at the board is to release decisions under the NRCB Act within 80 working days of concluding the hearing. This is not a statutory timeline, but it's a performance target that we've always met, and I see absolutely no reason why the board will not live up to that, or perhaps even beat this target for the SR1 decision. So in conclusion, it's been my privilege to serve on this board and to serve Albertans alongside panel members Mr. Sorosi, Dr. Heaney, and Ms. Roberts for the review of SR1. I'd like to thank everyone once again, and with that, this hearing is now closed. Thank you, everyone. We'll be releasing, as I say, our decision within 80 days, and all take care, and perhaps our paths will cross over the coming months and years. Thank you. Take care.
Thank you, Mr. Chairman. Well done.
Thank you, sir.
Thank you very much.
Chair, thank you for all your considerations.
You bet. And thanks, Mr. Weeb.
Thank you.
You're welcome.
All right. Take care, everyone.